I want to talk about getting your patent application unstuck. So does this sound familiar to you? You've been going back and forth with the examiner, you don't feel like you're getting anywhere, it's costing you a ton of money, and you feel like you're hitting a dead end. Stick around and watch the rest of the video because I'm going to give you a bunch of tips on how to get your patent application unstuck and take it from being rejected and rejected and rejected to being allowed and doing so cost effectively. So stick around, we are starting right now. So for those of you who are new here, my name is Dylan Adams. I'm a patent attorney and I represent clients of all sizes, from garage inventors to startups to Shark Tank companies to Fortune 500 companies as well. I'm also the author of the best-selling book Patents Demystified, which is an insider's guide to protecting ideas and inventions used by inventors, entrepreneurs, and startups worldwide, including at top universities like Harvard, Stanford, and MIT. You might also recognize me from my appearance on CNBC as well. This channel is all about giving you insider tips and tricks on the patent process and for startups and bringing your ideas and inventions to fruition. So be sure to subscribe, hit that little bell icon if you want more content about that. All right, let's go ahead and get right into it. Okay, so the first thing to realize about the patent process is that sometimes it is time consuming, it is difficult, and so sometimes what you're experiencing is just a natural part of the process, okay? You could get a bad examiner, or it just could be taking a long time because of how the application is set up, or they have to do a lot of prior art searches. So it's not always an issue. Sometimes it's just the natural course of things. So if you've only been rejected maybe 2 or 3 times, honestly, that's pretty average, and I wouldn't worry about it too much. It's only if you feel like you're not getting anywhere and there aren't positive signs about what's going on, that's where you really should be concerned about it. So one of the first things, and hopefully you're already doing this, is you really should work with a patent attorney if you feel like you're getting stuck. I see a lot of people, just going back and forth with the examiner, not getting anywhere because they don't understand what amendments to make, what arguments to make, and just how to frame things. And before you say, hey, well, Dylan, of course, you're a patent attorney, you want my business, so of course you're gonna say work with a patent attorney. Let me just tell you, okay, on principle, if you contact me and you want to work with me after watching this video, out of principle, I will not work with you. So I'm trying to just give you sort of the real scoop on what to do, and and try to be real about things like this. So again, I won't work with you. I'm not trying to get your business from this video. But like I'm saying, working with a patent attorney, that's a really great way to get your application unstuck. Patent attorneys, they know what to look for. A lot of times it can be really, really simple things that can take an application that's been rejected multiple times to being allowed the next round. Okay, so one of the best things that I could say that you can help get your application unstuck is conduct an examiner interview. And essentially what that is where you schedule a time to talk with the examiner, and usually it's gonna be with your patent attorney. I wouldn't suggest inventors doing that themselves unless you're doing it by yourself, which again, I wouldn't necessarily recommend. So you have your patent attorney conduct an interview with the examiner, and if they do it right, a lot of times they can talk to the examiner and say, hey, what are you noticing here? What are the problems? How can we get over the rejections? How can we move this case forward? And ask the examiner for their opinion. A lot of times, that's how I can get stuff allowed really, really easily. It's just talking to the examiner and saying, hey, what do you see here? What are your thoughts on this? And just getting them on your side, and then you can really get the case unstuck, and a lot of times you move it to allowance substantially faster. Another thing is during examination, if you feel like you're getting stuck, and especially if your attorney has just been making arguments and arguments and arguments, try making some claim amendments, even if they're just sort of clarifying things. A lot of times, you kind of want to give the examiner a win, and instead of just arguing and arguing, make some claim amendments. That can really change things. By that I mean, so the claims are really where the examination is. The claims are sort of those weird little single sentences at the end of the patent application that are worded in a weird sort of way. If you add content to that, if you sort of make the claims more narrow, it helps get around the prior art or sort of clarify things, and that can really help get the application unstuck if you're having problems. So another thing I notice is that sometimes, and attorneys can really do this too, they really get stuck on one point and they're really just going about things one single way. They say, the examiner's wrong about this, and I need to fight, and I need to fight, and I need to prove that I need to prove that I'm right. I'm gonna appeal and do all these things. Sometimes it just makes sense to change tack, do something different. There are a lot of ways to allowance. Instead of feeling like you need to be right and you need to prove to the examiner that you're right on this point, go about it another way. Like I use the analogy of of judo. And I'm not a martial arts guy, and this may be totally wrong. Tell me in the comments down below if this is a bad analogy. But so my understanding with judo is you kind of use your enemy's energy against them. And I guess the analogy there would be is, if the examiner's coming at you and you're battling and you're, fighting each other, just kind of go around that. It's like find the path of least resistance where things are easier. There's always another way around it. So I have this a lot where, I'll take over cases from somebody else, or even internally where I'm, there's other attorneys in my firm and we pass a case off. A lot of times the easiest thing to do is just change course and try something new, and that can get you to allowance pretty quickly. So another thing is, for instance, I talked about making amendments. Sometimes what you really need to do is make some really big, aggressive amendments. Add a lot of elements to your claims. Just, it helps to really teach the examiner what the invention is, and makes it really hard to find all those elements in the prior art. And what some people say is like, well, you don't want to do that because it narrows the claims, and then you have this patent that is way too narrow. Sometimes that's not a bad thing. If anything, start with claims that are really, really narrow, and then what you can do is file a continuation that then allows you to go after broader claims. Get some agreement with the examiner. That's the mistake I see people making all the time, is they just want to fight and fight and fight and go for the broadest claims in their first application. A lot of times what you can do is get some narrow claims allowed, get some agreement, get the examiner on your side in a first patent application, and then do a continuation to go after the broader claims. And a lot of times, then you can get multiple issued patents for probably the same cost, a lot of times less than you would, and with a lot less time as well. So it's okay, make some big amendments, try to move the case along and get some agreement with the examiner. Another thing that can help with getting your application unstuck is giving the examiner a lot of different options to allow the case. And this is a little bit more advanced and something that you may want to talk to your patent attorney about, but add a bunch of extra dependent claims with a bunch of potentially patentable elements to it, and have those as a bunch of other options that can lead to allowance of the case. So again, talk to your patent attorney about this, and that's one of the things that can be really important is, just asking for the right thing. Say, hey, let's add some new dependent claims that have some potential points of novelty to try to make it hard on the examiner to find these things in the prior art. Because what a lot of people do, they'll just make a single amendment, maybe just to the independent claims, but then you can have sort of backup positions as well in additional dependent claims, and that can be a great way to get to allowance. Make it difficult on the examiner to have to show all those things, and hey, maybe a lot of them don't work, but if one works, then you can easily get to allowance. You can take that point of novelty, put it into the independent claims, and suddenly the application is totally allowable really quickly. Now sometimes all you can really do is just try to wear the examiner down, and that's sort of the sad reality of things. So the examiners get points based on the work they do, and it can start to look bad for them if they've had a case in examination for too long, and sometimes you may just need to wear the examiner down, and that's sadly a viable thing to do. It can be expensive, but sometimes that's just what it takes. Another thing is, if the examiner just doesn't get it, sometimes you get a crappy examiner who doesn't get it or doesn't want to get it, isn't applying the law correctly, you're gonna have to appeal the case. Again, it's one of those things that's kind of expensive, and I really, really don't like to do it, but sometimes that's just necessary. Another issue too is, honestly, sometimes you may need to get a new patent attorney. And again, I want to go back to my disclaimer from before where I'm saying, hey, I won't work with you if you contact me because of this video. I'm trying to be unbiased here, but reality is you may need a new patent attorney. Some patent attorneys, they may not really get it, or they're just trying to churn the case and make a bunch of money, and they're not really trying to progress things. They would rather have you go back and forth with the examiner tons of times, and that's how they're making their money, instead of really trying to expedite things. Or maybe they just don't really, like they have a bad relationship with the examiner, like they've been really mean and really disrespectful, and the examiner's like, yeah, I'm not gonna let you get anything allowed. Sometimes you need to change attorneys, and that's gonna be the way to get things unstuck. So if you got some value out of this video, please take a second to give it a like, and also subscribe to the channel as well if you're looking for more insider content about patents, inventions, and startups. Got a lot of great content coming out on a regular basis. So also too, check out this video. This is about how to protect invention ideas, and this one too, this is about sort of like the best patent strategy, what I suggest for startups and inventors. So thanks for watching, really appreciate it, and we'll see you again in the next video.